Hello, in today's video, we shall be looking at another fact that establishes that a marriage has broken down irretrievably. A fact that establishes that a marriage has broken down irretrievably. And in this regard, we shall be looking at the provisions of Section 15(2) B of the Matrimonial Causes Act of Nigeria. Section 15(2) of the Matrimonial Causes Act of Nigeria. We have laid the foundation that the Matrimonial Causes Act of Nigeria has given us only one ground for dissolution of marriage, which is said is the fact that a marriage has broken down irretrievably. And now we are considering in this sequence of presentations those considerations that you bring before the court to establish this ground of dissolution of marriage. And in this respect, I'll share my screen as usual, and we are looking at the aspect that is called adultery and intolerability. Adultery and the fact of intolerability. And in this respect, the learning outcomes for this presentation are the following. At the end of the presentation, you'll be able to understand how adultery and intolerability can be effectively canvassed as a fact of the irretrievable breakdown of a statutory marriage. Don't forget the fact that we said that the provisions of the Matrimonial Causes Act apply to the statutory marriage in Nigeria. Then you would understand what kind of evidence can be presented before the court to establish the fact of adultery. You will understand the relationship between adultery and intolerability as a fact of dissolution of marriage. You will appreciate the standard of proof of adultery, whether it is civil standard or criminal standard, for instance. You would appreciate the use of discretion statements in litigation that has adultery as a component. You would know the limitation of time with respect to adultery and the damages that can be claimed in adultery. With all this knowledge, you should be able to apply this to case scenarios that are presented either as a law student or as a practitioner. So we go on, and Section 15(2) of the Matrimonial Causes Act of Nigeria that we have mentioned says that a marriage, you can establish the fact of irretrievable breakdown of a marriage if you can prove that since the marriage, the other party has committed adultery and you find it intolerable to live with that person. Section 15(2) of the Matrimonial Causes Act. And that section is referring to events that transpire after you have gotten married. Whatever takes place before the marriage is irrelevant before the law. It is what takes place after, since the time they got married, that are brought to bear to show that a marriage has broken down irretrievably with respect to adultery. So adultery and intolerability. One thing that must be noted is that adultery alone is not a fact of irretrievable breakdown of marriage. You cannot come to court and just assert adultery. You must also establish the twin components that you find it intolerable to live with the respondent. What kind of evidence, what is the relationship between these two will be explained later. Adultery in this regard means voluntary sexual intercourse between two people, one of whom is married to another person. So if one of the parties that have sexual intercourse is married to another person, that sexual intercourse constitutes adultery. So that means there must be sexual intercourse, it must be voluntary, that is intentional, deliberate, it must be consensual. If someone is raped, for instance, that is not adultery. It must be something that takes place after the person has gotten married, not before. Not premarital sex, it is post-marital, and it is expected to be with the opposite sex. If there is evidence of adultery and intolerability, then the person can successfully claim that the marriage has broken down irretrievably. In this context, how do you establish adultery? Usually it is circumstantial evidence. Circumstantial evidence. Such circumstances, because in hardly, of course, if they are caught in the act of adultery, that is direct evidence. But in case, and usually you don't have direct evidence of adultery. If you look at the case of Alabi against Alabi, there is comprehensive treatment of effect of adultery on dissolution of marriage. And so this circumstantial evidence would be evidence that there was familiarity and opportunity between the parties, that they are rather familiar and they also have the opportunity. But even if there's evidence that despite the opportunity, the couple did not commit adultery, of course, the evidence will not stand. If one of the parties, if the person you are claiming to have adultery, to have committed adultery, is suffering from a venereal disease, which was not contracted from the married partner, then that could be evidence of adultery. If the people that are alleged to have committed adultery are frequently visiting hotels, and other places that there is opportunity to commit adultery. Of course, this evidence is a question of fact before the court of each case. In cases like this, the circumstances of each case would determine if adultery has been established. Sometimes you have someone that will confess or admit that they've committed adultery. And so another evidence, circumstantial evidence, is that if the wife, for instance, gets pregnant and gives birth to a child that the husband could not have fathered. If, for instance, the husband has been away for the past 1 year and has not been near the wife, traditionally, that would have been easy to establish adultery. But we recognize, for instance, that in these days of science, some things that were not possible before are possible, like storing the sperm, for future use and what have you. So this shows us that invariably, the facts of each case will determine if that birth of that child is actually evidence of adultery. Because if, for instance, also you have issues that arise in surrogacy and what have you, yeah, and if a wife decides to be a surrogate with the husband's consent, for instance, that could be that she would have had a child that the husband could not have fathered or did not father, but that may not necessarily be the fact that she has committed adultery. Then you have the fact that there's cohabitation as husband and wife. If one person who is married, A is married to B, for instance, and B now decides to go and live, perhaps maybe she's transferred to another state and she begins to cohabit with another man as if they are husband and wife. That is a circumstantial evidence that she's living in adultery. Then where there is bigamy, where we know, for instance, that statutory marriage is a monogamous marriage. It does not accommodate the celebration of another marriage while that marriage is subsisting. So if a man were to, for instance, go and purportedly marry another woman, whether under customary law, under statute, under Islamic law, any other kind of law, when he is legally married under the Marriage Act of Nigeria, that is bigamy. And in that context, the fact of him in a bigamous relationship will be evidence of adultery, because the God is going to presume, and it's reasonable to presume anyway, that if you purport to be the husband of a woman, then you have had sexual intercourse with that person. Where there is omission of the husband's name from the birth certificate, if a wife were to go and obtain a birth certificate, for instance, and she puts another man's name as the father of that child, these are all circumstantial evidence, subject to prove or rebuttal by the court, before the court. Conviction for rape. A married man who rapes a person, commits who has sexual intercourse with it, who rapes a person, is, liable, for instance, to have the marriage dissolved for committing adultery. The wife would come to court and claim that because of the conviction for rape, there is evidence of adultery. This is a technical point. Then when the court orders DNA testing of a child, look at section 63 of the Child Rights Act. It permits DNA, court-ordered DNA and blood testing. So if the child that a wife gives birth to is proven, for instance, not to be the biological child of the husband, then the wife would have to explain how it came to be. There would that be a likelihood of a presumption that she has committed adultery. But like I noted earlier, we know that in this age of advances in science about assisted reproduction, there could be other explanations. If another woman were to claim to have had a child for the husband, and the child is either the husband admits it or it is established in any other way that that is the child of the husband, that is evidence of adultery. So adultery as a component of this section 15.2b that we are talking about can be proved circumstantially, since in most cases you may not have direct evidence of adultery. Some other things that should be noted regarding adultery is the fact that damages, a person can claim damages from the co-adulterer if, for instance, a wife was petitioning for divorce on the ground that the husband had committed adultery and she finds it intolerable to live with the husband. She could, if she names the specific person with whom he has committed adultery, claim damages from that co-adulterer. However, under section 31(1), that is where that right emanates from. Under section 31(2), damages will not be awarded where the adultery has been condoned. Condonation connotes the idea of forgiveness and reinstatement. So if the wife had, for instance, condoned the adultery, or where the petition for dissolution of marriage is not based on the fact of adultery, then damages will not be awarded. So you will notice two things there. If the wife, for instance, or the husband had condoned the act of adultery, the person will not be able to claim damages. Also, if the petition that for divorce is based on something else apart from the adultery, yes, the adultery is existing, but that is not the premise upon which the petition is based, then the damages may not be awarded. Then the damages will not be awarded if the adultery had been committed for more than 3 years before the date of the petition. More than 3 years before the date of the petition. So these are some of the conditions attached to this issue of adultery. Then under the matrimonial causes rules, order 11, rule 28, 29, 31, 1b, matrimonial causes rules, states that if a petitioner has committed adultery, the petitioner now, he should file his discretion statement. The adultery may be committed before filing the petition or after filing the petition, but before the proceedings commence, before the case starts. For instance, he has filed the petition today, December 14, 2023, and then he commits adultery December 24, 2023, and the case will be heard January 2025. He should file a discretion statement. Or the petition is filed today, December 14, 2023, but adultery was committed October 10, 2023. He should still file a discretion statement. The discretion statement must be made available to the respondent. It is meant to give an idea of the truth of the petition. It must be signed by the maker. It must be it must be in affidavit form. It must be enclosed in an envelope, sealed, and the words discretion statement written on it. And it must be signed by the attorney that is representing the petitioner. essence is to give a clear picture of what has taken place. Now, the damages for adultery, like I said earlier, can be claimed from someone with whom adultery has been committed, if the person is specified in the petition. The standard of proof for adultery is stated in Section 82(1) Matrimonial Causes Act. And the section says that because you want to prove adultery and you don't, you know that, like I said earlier, although you may have direct evidence, maybe somebody catches them in the act, maybe they are recorded, there is direct evidence of adultery. That would be fine. But there could be, most of the times, circumstantial evidence, like the ones that we have talked about, form the basis of petition for adultery. I mean, petition of establishing evidence of adultery. Now, for the court to be satisfied, since you are relying on circumstantial evidence, for example, you are saying there's familiarity and there's opportunity, or they are very close and they are very known to be going about and they are frequenting hotels, and the court has to make a decision based on those circumstances. For the purposes of this of the divorce petition, Section 82(1), MCA says, for the purpose of the act, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of the court. Because ordinarily you want to say, oh, adultery is a crime, and it should be based on proof beyond reasonable doubt, or balance of probabilities because it's a civil case. But the section says proof, established to the reasonable satisfaction of the court. And some people have argued and said, look, adultery is in a class of its own in terms of proof when it comes to matrimonial causes. So you can see Section 82(2) as well, which talks about the provisions of the MCA, any facts that you want to prove under the MCA. It would be sufficient if it's reasonable, if it is proved to the court and the court is reasonably satisfied of the existence of that ground. So what is reasonable satisfaction for the court is a question of fact. It would seem that it hangs in the balance between the criminal standard and the civil standard. So these are some of the issues that we the MCA make as condition for adultery to be established. These are some of the conditions. The second harm of the MCA provision is about intolerability. I said earlier that it is not sufficient to just prove adultery. You also have to say that the person has committed adultery and the petitioner finds it intolerable to live with the respondent. And it has been said that this ground must also be established. So, for instance, if somebody has committed adultery the first time and subsequently commits adultery again, the second act of adultery may be the fact that shows that there's intolerability. And you have had cases where the courts have held, for instance, that, okay, the woman committed adultery with the house help on the matrimonial bed. That adultery itself is there. Then the fact that it was in the home with the house help is evidence of the fact that that person finds it intolerable to live with the respondent. So it's like there are aggravated facts again that exist beyond adultery. The foundation of that provision lies in the fact that if you remember the way we talked about the history of divorce law, there was even a time that divorce was not possible in English law, from which these provisions were borrowed. And when it was allowed eventually for a woman to get the marriage dissolved on the grounds of adultery, the law required, English matrimonial causes law required that the woman establishes not only that the husband had committed adultery, but that he had also committed another matrimonial offense. when they were working with the offense theory, whereas the man would get a divorce based purely on the fact that the wife had committed adultery. So this provision that now ties adultery and intolerability together is a snippet of what used to be in place. But in this regard, whether it's a man or a woman, you not only prove adultery, you must also establish some other facts surrounding the marriage, which makes it intolerable for the petitioner to continue to live with the respondent. So in a situation where a man has committed adultery, for instance, and then insists that the adulterer must be accepted by the wife into the matrimonial home, the court was prepared to actually hold that yes, there is adultery, and the actions and the behavior of the husband is something that the wife cannot reasonably be expected to live with. So under the Matrimonial Causes Act, we must note these critical points, that adultery and intolerability must be established together. And once they are established, that is another ground upon which a marriage could be dissolved. In the next presentation, we shall be looking at the third fact of irretrievable breakdown of marriage under Section 15(2)(c) of the Matrimonial Causes Act of Nigeria. So I'll see you at the next video. Thank you.